Hello. So this is my presentation on Whole Women's Health v. Hellerstedt. This is a Supreme Court case regarding abortion, which has been a very relevant topic as of recent. This is a very pivotal case in the topic. To start off with the facts of the case, in 2013, the state of Texas passed House Bill 2, which required abortion providers to have admitting privileges at local hospitals and also meet ambulatory surgical center standards, which were more stringent standards than what had already been applied for abortion providers in the state. This suit was brought by abortion providers in Texas against the Texas Department of Health, arguing they were denied equal protection and this constituted unreasonable state action. Then the case was brought to district court and appeals court. Both times the claims were dismissed, but there was an injunction placed against the enforcement of this law before the Supreme Court granted certiorari in November 2015. So the issue in this case is, does a Texas law that required abortion providers to have admitting privileges at nearby hospitals and required abortion clinics to meet strict infrastructure standards violate a woman's right to an abortion under the 14th Amendment? The case was decided as follows. It was a 5-3 decision, with Justice Kennedy being the one conservative justice that flipped over to the liberal side. And this was also during the time after Justice Scalia had passed and the Republican Senate was refusing to confirm Merrick Garland. So there was only 8 justices present for the case. The majority opinion was written by Justice Breyer, who used the substantial burden test from the precedent of Planned Parenthood v. Casey, and pointed out that the medical benefits for women that may stem from these provisions are not sufficient to justify abridging their abortion rights. So proponents of this bill argued that it was done to protect women and promote their health and their safety. He dismissed that as it was not sufficient, and that this action does indeed place a substantial burden by causing half of the state's abortion clinics to close, making it much harder for women to receive an abortion. Concurring opinion was written by Justice Ginsburg, who wrote that modern abortions are very safe and rarely lead to hospitalization compared to other medical procedures, including childbirth. And she also pointed out that any law made restricting the abortion rights of women made in the name of protecting women's health would not pass judicial review. So she pointed out that that argument can be a guise for restricting abortion rights when it's incorrect to do so. Justice Thomas wrote an dissenting opinion in which he stated that the majority opinion misinterpreted the precedent, including Planned Parenthood v. Casey, and that they misused the unburdened test and treated it similar to strict scrutiny when the two standards are separated from one another. And he creates a term called meaningless formalism, in which he says that having so many different precedents and standards and tests to use makes it overly complicated, especially for deciding these courts at the lower level. And then he also pointed out there were issues of standing regarding abortion providers bringing the suit on behalf of women seeking abortions, saying that this was a third party bringing a case on behalf of another party. And Justice Alito also wrote a dissenting opinion in which he said that there were issues, again, of standing and certiorari granting. And he also said that the petitioners did not show causation from the law causing abortion providers to close, only correlation. And he said that that does not present an undue burden for women to have an abortion. My thoughts on this case is that I think this case was correctly decided, and I'm happy that this was the decision that was made. I think laws such as this one or the heartbeat bills that have been passed recently, whether they're done in the name of protecting women's health or protecting the rights of the unborn, the effect that they have is making it much more difficult for women to receive an abortion. And when we look at the precedent from Planned Parenthood v. Casey to say that you can't place an undue burden on women, I think this case was correctly decided. Here's an infographic that shows that this law made it much harder for women to receive an abortion, making it more far away from abortion clinics across the state, making it more expensive, and also just increasing the number of women who wanted to receive an abortion but couldn't have one. What makes this case interesting, looking forward to the future, is the makeup of the court. At the time, Justice Scalia had passed away, so it was only 8 justices, but he was then replaced later on by Justice Gorsuch. And Justice Kennedy, the one conservative justice who flipped in this case, has since been replaced by Justice Kavanaugh. seen Lovely here, who is much more conservative on him in issues like this. So with these two justices on the court, if there were an analogous case brought today, we could very well see this case be decided the other way around via 4-5 decision, and see laws such as this one be upheld, like the current heartbeat bills that have been passed within the most recent year or two. So it's an interesting and ongoing topic, and it's interesting to see where it will go next. All right, well, thank you very much, and have a great day.